The two questions being asked are whether it is legal to scrape websites' publicly available data, and if it is legal to display that scraped data on your own website. The general rule is that it is not illegal to scrape data in and of itself. The legality of scraping data will really depend on what data is being scraped, the methods being used to scrape it, and how that data, once scraped, is used. So, a couple of issues that I would want to consider really break down into five different areas: statutory, intellectual property, privacy, contract, and tort. I'll take those each in turn. Statutory, primarily, you are concerned with federal laws such as the Computer Fraud and Abuse Act, which makes it a federal crime to access a computer without authorization or to exceed the authorized access that you have been given. Intellectual property concerns, be concerned about infringing on someone's copyrights or trademarks or misappropriating their intellectual property. For privacy concerns, that is more about what the data that you are scraping actually is, and if anyone has any claims to privacy. Those privacy concerns, particularly in the EU with the GDPR. California has its own Consumer Privacy Act, which attempts to do some of what the GDPR does in the United States, and HIPAA, protecting health-related information. Contract concerns involved with web scraping are primarily whether a website's terms of use indicate that data scraping of their website is a violation of those terms of use. Most websites do indicate that scraping data from their websites is a violation of those terms of use, and that could give rise to contract liability. Tort claims really have to do with what your conduct is with regard to the scraped data, whether it's intentional or negligent, and whether you might be violating anyone's common law privacy rights. Two cases that I think are worth looking at in particular about web scraping. The first, HiQ Labs versus LinkedIn Corporation. And in that case, HiQ's scraping did not violate the Computer Fraud and Abuse Act. LinkedIn was not allowed to use the CFAA to restrict access, and it was mostly, in my opinion, based on the fact that the information was publicly available on LinkedIn's site. Interesting, because LinkedIn does employ membership. You need to register, you need to have a password. So anyone can sign up to become a member of LinkedIn's site, but it's not publicly available without becoming a member of the site and agreeing to the terms of use of that site. But the court refused to enjoin HiQ from scraping LinkedIn's data because of that data being publicly available. The court specifically said the CFAA's prohibition on accessing a computer without authorization is violated when a person circumvents a computer's generally applicable rules regarding access permissions, such as username and password requirements, to gain access to a computer. It is likely that when a computer network generally permits public access to its data, a user's accessing that publicly available data will not constitute access without authorization under the CFAA. The data HiQ seeks to access is not owned by LinkedIn and has not been demarcated by LinkedIn as private. Another case, the Facebook versus BrandTotal case. In that case, the court did enjoin BrandTotal, finding that the scraping violated Facebook's terms of service and that Facebook would likely succeed on its breach of contract claims against BrandTotal. So two different results based on two different theories of law in different cases. One where web scraping was expressly permitted by the court, and one where web scraping was expressly forbidden by the court. That's a good introduction. Again, the legality of the web scraping is going to depend on what you scrape, how you scrape, and how you use that scrape data. If there are any other questions, please let me know.